my appearance, my lord. J.O. Ipopo Martins. With me is A. Calm.
Sorry, I'm coming. Sorry. Hold on for a while.
For the defendants, my lord. J.O.
Okay, you are in the first matter. Isaac Owayo Obokwe, Juba Chooks Regina.
Yes, my lord, we are in Isaac Owayo Obuakewe. Isaac Obuakewe against John Paul.
I think my lord is off the Zoom now. My lord got disconnected.
Okay. Please, can you... Which matter is called?
No matter has been called yet. So wait for them to... None has been called.
Thanks. It's all right. Thank you so much.
You're welcome, sir.
Thank you. One out of the register, which number do I matter? No, we're not there now. I know that. I never bet.
Yes, sorry for the technical hitch.
We are sorry, my lord.
Yes.
My lord, I am in the case of Isaac Obuakewe against John Paul. I don't know if that the case has been mentioned, my lord.
Yes, that's number one.
Okay, I'm grateful, my lord.
Mr. John Ipopo Martins, you say you appeared with whom?
A. Calm, K-A-M, Calm, A. Calm.
A. Calm.
Yes, for the defendants.
Claimants not represented? Anybody for the claimant? Claimants? Nobody.
MC Owusun is the counsel for the claimant.
Yes, I think he's not online. So this is the decision of the court. The claimants filed a complaint pursuant to the 3 Rule 2 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 on the 19th day of November 2019. Whereas the claimants' claims against the defendants as follows: an order directing the first defendant to stop parading himself as the chairman of NASWEDEN Delta State Chapter forthwith, an order directing the first defendant to render account of his stewardship from April 2017, when he was appointed as the Delta State Chairman of NASWEDEN by the National Executive of the Union in September 2017 to September 2018, when he was removed. An order directing the first defendant with the second and the third defendants who worked closely with the first defendant to hand over all Union's documents and properties in their possession to Delta State Council of the Union. An order directing the first defendant to produce statement of account in First Bank Nigeria PLC and Zenith Bank Nigeria PLC from the period he assumed office till date, which account large monies belonging to the union. An order directing the first defendant to pay interest at the rate of 21% per annum for all monies belonging to the union in his personal account or possession. An order directing the defendants to pay the sum of 2 million naira in favor of the claimants as cause for instituting this action. The claimants predicated their claims on the statement of facts filed on the 19th day of November 2019 and replied to statement of defense filed on the 23rd day of March 2020. The defendants in turn based their defense on the statement of defense filed on the 26th day of February 2020. Isaac Oyabero, who testified as CW1, identified his witness deposition on oath made on the 19th day of November 2019, an additional deposition on oath made on the 23rd day of March 2020, and adopted same as his evidence in the aid of the claimant's claims. CW1 stated that he is the current chairman of National Association of Scrap and Waste Dealers Employers of Nigeria, Delta State Council, that the second and the third claimants are the secretary and ex-officio members of the National Association of Scrap and Waste Dealers Employers of Nigeria, Delta State Council, respectively. That by virtue of Rule 9 of the Constitution of the Association, the state or geographical areas are empowered to establish state or geographical council, hence the Delta State Council. That on the 23rd day of March 2019, the Delta State Council of the Association held a state congress wherein the claimants, among others, were elected as executive of the State Council to oversee the affairs of the association in the state. That the Congress was convened by the Caretaker Committee of Delta State Council, which was set up by the National Executive, which was conveyed to the Delta State Council via the letter dated September 3rd, 2018, and signed by Otegon, Honorable Uko Uwadofia, the Secretary General of the Association. That the appointment of the Caretaker Committee was equal to the determination of the appointment of the first defendant as the chairman of Delta State Council of the Association, which was only for an interim period, pending when the State Council will properly elect its own executives. That at the end of the State Delegate Conference, held on the 23rd day of March 2019, that elected the present executives and has the claimants as members, a communique and the resolutions arrived thereat was issued. That the Board of Trustees and the National Executive of the Association were duly notified of the Congress. That the Congress was overseen by Mr. Daniel Orisejo, a Board of Trustee member, and Mr. Uko Wadofia, after the National Executive and Board of Trustees were duly notified that by the Constitution of the Association, the first defendant is a stop from paying claim to being the state chairman of the association, as he, by his own showing, has asserted that he's a National Executive member, that his predecessor in office, Comrade Daniel, upon becoming the vice president, southeast of the association, relinquished his position as chairman of the Delta State Council of the Association. That prior to the State Congress, the first defendant was the erstwhile chairman of Delta State Council of the Association, even though his appointment by the exclusion of time ends on the 30th day of August 2018. And the National Executive, through the Secretary General by a letter dated 3rd day of September 2018, had to set up a 5-man caretaker committee. CWM further stated that the second and third defendants, though not elected nor appointed by either the National or the Delta State Council, were handpicked by the first defendant. The first defendant executed his responsibilities, especially that of collecting revenue for the claimant, through the second and the third defendants, who acted as his personal assistants. And though they were not members of the association, that some of the monies belonging to the association, which the first defendant, with the connivance of second and third defendants, which the first defendant lodged into his personal account, were clearance fees for loading of scrap and waste, ranging from 10 to 20,000 naira, depending on the size of the truck to end user factory. That the books and records of the association were arbitrarily given to the second and third defendants by the first defendant. CWM further stated that no member of the claimant was at any time expelled by the association, whether at the national or state level, that the assertion of the defendants in their proceed paragraphs as contained in their defense, the purported expulsion letters of the claimants were made by the defendants solely for the purpose of this case. He said no such letter was either issued or received by any member of the claimants, that the copies of the purported expulsion letters were only purportedly signed by the then national president and was said by the defendants to be the decision of the National Executive Council. That in accordance with the constitution of the association, the responsibility of conveying the decision of National Executive Council solely resides in or vests on the Secretary General of the Union. That the Secretary General is also the custodian of the nominal role of the association. That the assertion of the defendants that there was Congress of the Union on the 23rd day of March 2019 amounts to denying same solely because they did not attend. Their non-attendance is not unconnected with the fact that, as at the time of the Congress, the first defendant was already assuming the office as the National Secretary of the Union, as can be clearly seen from the plethora documents which he signed as such. That the State Congress of the Association of Niger, that the State Congress of the Association of Delta State Chapter duly held on the 23rd day of March 2019, that to the best of their knowledge, Honorable Uko Udofia was and still the Secretary General of the Union, not just as Secretary, but the two factions of the Union at the national level still recognize him as such. Hence, he signed the resolution reached by the faction on the 5th day of September 2019. That the first defendant has ceased to be the Delta State Chairman of the association, as he failed to conduct a state executive elective Congress after 6 months of his appointment as chairman. He was also unanimously removed by the State Executive Council, SEC, and he failed to show up or stand for election when elective Congress was called. That the second and the third defendants are total strangers to the state chapter of the association and are only mere creations of the first defendant, which he used to perpetrate his fraudulent activities against the union. CWM further stated that Comrade Dan Orije Sobo was the Pioneer State Chapter Chairman, former Vice President South-South, a founding father and Board of Trustee member of the union. The position of Board of Trustee member and founding father position are for life. Hence, the allegation of the defendant that Comrade Dan Orije Sobo was expelled only exists as a figment of the defendant's imagination. That invitation to Comrade Dan and Honorable Iwa Udofia was only based on courtesy, as their attendance or otherwise does not in any way affect the authenticity of the Congress as is provided for in the Constitution of the Union. That the then president does not have the unilateral powers to expel any member, that no National Executive Council meeting of the Union was held where the decision to expel the claimants was taken, that the claimants have no knowledge of any law office known as Ejirogene and Co. This is a creation of the defendant made solely for this case. That the allegation that CW1 was given the sum of 70,000 naira only to open the union's account is a blatant lie by men who are looking for any straw to hold on to in order to avoid sinking. That the union could not open the accounts due to the first defendant's insistence that he and any other person can sign checks, contrary to the provisions of the union's constitution, which the bank refused to waive. First defendant's attention was called to the bank's position, but rather than changing the mandate as required by the union's constitution, he resorted to paying the union's money into his personal accounts, which monies he has not accounted for till date. CWN tendered the following documents and some were admitted in evidence and marked accordingly as follows. The Constitution of the National Association of Scrap and Waste Dealers Employers of Nigeria admitted and marked as Exhibit CW001, letter from Nasweden and addressed to the Commissioner of Police Delta State dated 25th March 2019, admitted and marked as Exhibit CW002, letter from Nasweden dated September 3rd, 2018, and addressed to Comrade Isaac Obaro Obukwe, marked and admitted as Exhibit CW003, communique or resolution dated 23rd March 2019, admitted and marked as Exhibit CW004, CTC of the Certificate of Registration of Trade Union, admitted and marked as Exhibit CW005, specimen signature card of Diamond Bank and letter of resolution dated 10th October 2017 and addressed to the branch manager, Diamond Bank, admitted and marked as Exhibit CW006A to B, respectively, and CW1 was cross-examined. So I will skip the cross-examination. When you get the judgment, you see it there. I will now go into the evidence of DW1. DW1 is one Mr. John Paul Omenu, who testified as DW1, identified his deposition and oath made on the 20th day of February 2020, and adopted same as his evidence in support of the case of the defendants. DW1 stated that the claimants are expelled members of the Delta State chapter of National Association of Scrap and Waste Dealers and Employers of Nigeria, that he is the chairman of the said association Delta State chapter, that the second defendant is the secretary, and the third defendant is the staff of the secretariat of the office, respectively, that no Congress was held by the Delta State chapter on the 23rd day of March 2019 or at any other time, that there is nothing like a caretaker committee in Delta State chapter which summoned a Congress, that there was no election held and the claimants were not elected, nor was anyone elected into a Delta State Executive Committee of the Union, that Delta State chapter on the 23rd day of March 2019 or at any other time, that Mr. Uko Wodofia was no longer the secretary of the union as from 16th day of August 2018, having been expelled from the association, that Mr. Daniel Orisejobo is not a member of the Board of Trustees, having been suspended on the 31st day of August 2018, where the resolution of the National Delegate Conference of the Association for anti-union activities, and particularly for taking the national president to court in suit number NICN ABJ 237-2018 between Alhaji Suleiman Latif and 5 others against Comrade John Egaji and 2 others. He was certainly not representing the association to oversee a congress that never held or otherwise a gathering of non-union members, that there was an executive committee of the state chapter of the association that included the claimants. But because of anti-union activities and constant fomenting of crisis, the claimants were expelled by the national president of the association. When the claimants were expelled, they caused a letter to be written on their behalf by the office of Ejiro Gene and Co. to him, that he instructed the office of Ikoko Okerega and Co. to respond to his behalf, on his behalf. The decision to open an account was taken by the association and all formalities were concluded, and the signed documents deposited with the bank awaiting formal opening by depositing money. That the sum of 70,000 naira was given to the first claimant by DW1 to deposit and conclude the opening of the account. But the first claimant rather misappropriated the money, hence the bank account was never opened. That the allegations of misappropriation of funds are just the figment of the imagination of the claimants. That the executive committee of the Union Delta State chapter calls and meet regularly where expenditures are approved, that the monies of the association are not paid into the account of the first defendant. DW1 tendered the following documents and some were admitted and marked accordingly. The solicitor's letter from Ejiro Gene and Co. dated 14th day of March 2018 and addressed to DW1, admitted and marked as exhibit DW001, solicitor's letter from Ikoko and Co. dated 20th March 2018, admitted and marked as exhibit DW002, letter of expulsion of the first claimant dated 29th January 2018, admitted and marked as exhibit DW003, letter of expulsion of the second claimant dated 29th January 2018, admitted and marked as exhibit DW004, letter of expulsion of the third claimant dated 29th January 2018, admitted and marked as exhibit DW005, memo dated 10th August 2018, addressed to all organs of the Union, admitted and marked as exhibit DW006 respectively, and DW1 was cross-examined by counsel claimants. After the close of the hearing, the defendants identified their final written address filed on the 4th day of April 2022, and adopted same as their legal submission in support of the case of the defendants. The claimants, in turn, identified their final written address filed on the 10th day of May 2022 and adopted same as their submission in support of their claims and urged this court to grant all the relief sought. The claimants nominated a sole issue for determination, to wit, whether the claimants have not discharged the onus placed on them by law as to be entitled to their claims. The defendants nominated 3 issues for determination of this suit. That is, whether the claimants are members, NASWEDEN, and can competently bring an action on behalf of the association having been expelled. And secondly, whether the claimants have a cause of action against the defendants. And thirdly, whether the claimants have sufficient evidence in proof of their case. Having closely perused the claimants' claims and the evidence led from both sides and arguments of counsel in support of their case, the court is inclined to adopt the sole issue formulated by the claimants. It is hoped that the issue so formulated by the claimants' counsel is so apt and all-encompassing to accommodate the concerns or issues raised by counsel for the defendants. It goes without saying that civil actions such as this present suit before me are determined on preponderance of evidence and balance of probabilities. And once a party asserts that he must prove his assertion, otherwise judgment will not be given in his own favor. See the cases of Okeke against Okeke, SCC Nigeria Limited against Elemadu, Imana against Robinson, Elias against Omobari, and George against UB, all citation provided. In this suit, the claimants who dragged the defendants to court and assert certain rights against the defendants shoulder the burden to prove their case on preponderance of evidence. While proving their case, the claimants must rely on the strength of their case, not on the weakness of the defense. See the case of Nemantex Associates against Masco Construction Company Limited, where the Court of Appeal held, and I quote, "The burden or onus of proof, particularly in civil matter, is not static. It at times acts like a pendulum in the judicial process. It shifts from the plaintiff to the defendant and vice versa from time to time. But one basic rule is that the plaintiff must succeed on the strength of his case and not on the weakness of the defendant's case, in the sense of inaction on the part of the defendant. However, where the weakness of the defendant's case materially strengthens the case of the plaintiff in particular area or areas, the plaintiff is entitled to rely on it. In other words, the defendant's case is not only weak, but the weakness proves essential ingredients of the plaintiff's case. In such circumstances, the plaintiff is entitled to strengthen his case on that of the defendant. Unquote. The claimants, by their statement of fact and evidence, stated that the claimants are the chairman, secretary, and ex officio members of the National Association of Scrap and Waste Dealers Employers of Nigeria Delta State Council. This environment suggests that the claimants are the members of the National Association of Scrap and Waste Dealers Employers of Nigeria, but belong to the Delta State chapter. The defendants, in denying this environment, bear their statement of defense, stated that the claimants are not members of National Association of Scrap and Waste Dealers Employers of Nigeria or Delta State chapter of the National Association of Scrap and Waste Dealers Employers of Nigeria, that the claimant were expelled from the association. The defendant tendered exhibits DW003, DW004, and DW005, being the letters of expulsion of the claimants. Exhibit DW003, DW004, and DW005 were dated the 29th day of January 2018. The claimants in denial, via their reply, maintain that they are members of the National Association of Scrap and Waste Dealers Employers of Nigeria and denied the knowledge of exhibits DW003, DW004, and DW005. But the defendants, through DW1, under cross-examination, stated that the letter of suspension was communicated to the defendants, that the national body sent the expulsion letters of the claimants to DW1 to serve unto them. He gave the claimants the letters during a meeting sometimes in 2017, and he asked them to make endorsement, but they refused to sign an acknowledgement. Learned counsel for the claimants argued that paragraph 4.7, 4.8 of the final written address that the first defendant's exhibits DW003 to DW005 purported to have been predicated upon a petition written by the first defendant against the named claimants, that it is uncontroverted fact that the claimants did not become aware of the purported expulsion until after the institution of this case. That according to the association's constitution, it is the duty of the NEC to apportion disciplinary action on any erring member or members, but the defendant failed to produce such NEC meeting that ever held. Counsel further argued that, assuming such meeting was held, it was the duty of the General Secretary, not the claimant or the National President, to communicate the decision of such meetings to other organs or members of the association. The defendants argued that the claimants do not have local standard to institute this action, since the claimant has since ceased to be members of the association long before the alleged date wherein they held the purported Congress, electing the claimants as officials, as they claim, that the claimants had all been expelled from being members of the association. The court, having painstakingly perused the evidence before this court, it is clear to this court that the claimant denied the knowledge of exhibits DW003, DW004, and DW005. Though DW1 stated that he served the claimants with exhibit DW003, DW004, and DW005 and asked them to acknowledge it, but the claimant refused to do so. In an attempt to prove before this court that the claimants are aware of the said exhibits DW003 to 5, the defendants tendered exhibit DW001, the letter written on behalf of the claimants, and the defendants' response in exhibit DW002 to exhibit DW001. Considering exhibit DW001 and DW002, could it be true that the claimants are not aware of exhibit DW003 to DW005? Although the claimants deny causing exhibit DW001 to be written in response to exhibit DW003 to 005. Exhibit DW002 makes this court to believe that the claimants are aware of exhibits DW003, DW004, and DW005 on the premise that exhibit DW002, which is a response to exhibit DW001, was dispatched via a courier service. Assuming evidence of DW1 is not credible enough to establish that the claimants are aware of their expulsion through exhibit DW003 to DW005 due to the resentment between the claimants and the defendants, then on what basis will exhibit DW001 come up that will necessitate exhibit DW002 at the instance of the defendants? In the case of OT against EFCC, reported in 2020, 14 NWLR at 1743, page 48, at 103, paragraph E to J, the Court of Appeal held, and I quote, in a case where it is alleged that a document was delivered to a person who denied receiving it, proof of delivery can only be established by a dispatch book acknowledging receipt thereof, or evidence of its dispatch by registered post, or by evidence of a witness credible enough that the person was served with the said document. Unquote. Premise on exhibit DW001 and DW002. I disbelieve the claimants on their denial of the awareness of exhibit DW003, 4, and 5. If the claimants are not aware of exhibit DW003, 4, and 5, I wonder how exhibit DW001, which is a reaction to the said exhibits for expulsion, will have come up out of the blue. Furthermore, the claimants argue that the defendants failed to show the rules of natural justice of audi alteram partem and the constitution of the association in purporting to do so. It is my stance that this argument is unavailing and cannot hold water based on 3 reasons. First reason of it, from the pleading before this court and the relief sought by the claimants do not challenge the legality or otherwise of exhibit DW003 to DW005. Neither the claimants pleaded that they were not afforded fair hearing to enable the defendants appropriately respond to it. It is trite that where a fact is not pleaded There is no room for leading evidence in proof of an unpleaded fact. See the case of Daily Tel Publishing Company Limited against a Kuwait citation provider. The claimant only raised the issue of fair hearing in their final written address, and authorities galore to the effect that final written address of a council, no matter its persuasiveness and prudence, can never take place of credible evidence. See the case of Nitel Limited against Okeke. Besides, exhibit DW003 to DW005 were issued by the national body of the Claimants Association and filed and signed by their national president, John Egaji Obi. Their national body being a juristic person and their national president were not joined to this suit to respond to the issue of fair hearing. Thirdly, the defendants are sued in their capacity as individual, but not as representatives of the national body of the association or the author of exhibits DW003, 4, and 5. The defendants are not the authors of the said exhibits, hence cannot be responsible for their contents or how they came about. In the case of Jegede against INEC, reported in 2021, 14 NWLR, part 1797, 409 at page 559 to 560, paragraphs F to D, where the Supreme Court held, and I quote, "So the contention that Governor Maiba Alabuni, as the governor of Yobe State, has violated Section 183 of the Constitution by holding the office of acting national chairman of the second respondent. It's a very serious one with grave consequences for him and no doubt for the second respondent as well. The judicial determination of that issue here will involve the enforcement of the Constitution against him, and it will certainly affect him personally, as I have shown above. It will be unfair to him to try that issue in his absence without joining him as a party to the petition. The fair trial of such issue in his absence without joining him as a party is impossible. There is no need to stress the point that he is a necessary party to the case, because the issue upon which the appellants have predicated their case, namely the invalidity of Mailabuni's signature and exhibit P21 and the invalidity of the said exhibit itself, cannot be fairly and effectually and conclusively determined without joining Mailabuni as a party to the case. A necessary party is one whose right to interest will be affected by determination of the dispute, and dispute cannot be fairly, effectually, and properly resolved in its absence. This resentment has been made by this court in several cases. The exception to the rule that non-joinder of a necessary party to an action may not vitiate the action is where the non-joinder makes the fair and effectual trial of the case impossible. Unquote. Given the position of the law as initiated above, non-joinder of the National Association of Scrap and Waste Dealers Employers of Nigeria and the national president of the association who authored exhibit DW003, DW004, and DW005 rendered the contention of the claimants as to fair hearing before dishing out exhibit DW004 to 5 in court. Finally, the claimants' counsel contended that exhibit DW003, 4, and 5 ought to have been communicated by the general secretary of the association instead of the national president. I agree with the claimants on this given because the provision of Article 14.1J of Exhibit CW001, which is a constitution of the Union, but Rule 14.1C provides that the national president can sign the minutes and other official documents of the association. I found no deficiency in Exhibit DW003, 4, and 5. It is therefore the finding of this court that the claimants failed to prove to this court that they are members of the National Association of Scrap and Waste Dealers Employers of Nigeria. Hence, any attempt to consider the claim of the claimants will be akin to searching for shadow in the darkness. The claims of the claimants against the defendants are hereby refused. The suit filed by the claimants is hereby dismissed for lacking in merit, and I make no order as to cost, and judgment is hereby entered accordingly.
As the court pleases.
Yes, Mr. Nwosu, you are just coming. Let me
Yes,
record you.
my Lord, I apologize, sir. I was having some difficulties with the technical aspect of the hearing, sir.
Okay, Mr. MC Nwosu
MC Wonsu for the
for
claimants.
the claimants.
Yes, my learned friend, AC Alubi, appears with me for the claimants. Sir. Most obliged.
AC Alubi.
Yes, my lord. CA.
Okay, CA Alubi.
CA, yes, Chima Amos Alubi. Yes.
Okay.
Lord, we are grateful for the judgment. Sir.
Okay. Thank you.
We lost.
You have not lost hope.
I say we should have joined the obey to the case. That the allegation that we made against it cannot be determined in his absence.
Yes, the next case.
Awesome.
Yes, appearance. Yes.
May I please the court?
Yes.
Ahmed Adetola Kazim. Okay. There are people in. Okay. Okay. Ahmed Adetola Kazim for the respondent. For the defendant. First defendant, my lord.
Yes. Yes.
Second defendant.
Yes. Claimants not represented.
Oh, then.
Answer to the claimant, Martin Wabo. He has not joined.
We didn't give enough.
Yes, this is a judgment of the court. The claimant filed a complaint pursuant to Order 3, Rule 2 of the National Industrial Court of Nigeria, Civil Procedure Rules 2017, on the 19th day of November 2020, with an amended court. An amended complaint was filed on the 16th day of March 2021, whereas the claimant's claim against the defendants, the following reliefs. A declaration that the claimants are not members of the first defendant union, having willingly withdrawn their membership from the first defendant union, an order of perpetual injunction restraining the second defendant from further deducting check of dues from the claimant's salaries and paying same to the first defendant, an order directing the first defendant to pay to the first claimant the sum of 390,832 naira, 22 kobo only, and the total amount of money received from the claimant's salaries as check of dues from the month of September, October, and November 2020. An order directing the first defendant to pay the sum of 132,277 naira only as the calculated sum of monthly check of dues received by the first defendant as check of dues from salaries of the claimant pending the determination of this suit. An order granting the claimants the sum of 500,000 naira as general damages for the untold hardship the claimants have gone through against the first defendant, and any other consequential order or orders as this honorable court may deem fit to make in the circumstances. The first defendant, on the other hand, Counterclaim against the claimants the following reliefs: a declaration that the claimants are no longer entitled to benefit from all the privileges attached to the membership of the first defendant as a result of their withdrawal from the first defendant. A declaration that the claimants are not entitled to enjoy all benefits arising from negotiations undertaken by the first defendant, including increased salaries, wages, commissions, allowances, and other work-related emoluments from the date adjudged to be the date of withdrawal from the first defendant. An order directing the second defendant to exclude the claimants from all benefits arising from negotiations or collective bargaining agreement championed by the first defendant from the date of their withdrawal from the union. An order granting the first defendant the sum of 500,000 naira as exemplary damages against all the claimants to prevent further malicious and unwarranted suit of this nature in future. The claimants predicated their claim on the amended statement of facts filed on the 16th day of March 2021. The first defendant counterclaimant's claim is premised on the amended statement of defense and counterclaim filed on the 16th day of June 2021. The second defendant too found its defense to the claimant's claim on the statement of defense filed on the 12th day of March 2021. CW1 is one Ogoni Appellant who testified and identified his deposition on oath made on the 16th day of March 2021 and adopted same as his evidence in proving the claim of the claimants, that the claimants were financial members of the first defendant and were diligent in all the union activities, that due to some of the activities of the union that were not satisfactory to the claimants, they decided to tender their resignation from the union. They are open tendering their resignation from the first defendant union, the Asa State branch. The claimants' letters of resignation to the first defendant and also copied the second defendant, expressing their desire to leave the first defendant's union, and also informed the first and second defendants to stop any form of deduction or check of dues from their salaries, as they are no longer members. That after the said letters of withdrawal of membership were served on the first defendant and sent duly recorded, the claimants were surprised to see that check of dues were still deducted from their salaries, to their utter dismay. That having been dissatisfied with the first and second defendants or related efforts to deduct check of dues from their salaries, some of the claimants contacted their counsel to write a letter to the defendants expressing their concern about the constant deduction of check of dues from their salaries by the defendants. That several efforts were made by the claimants to stop the defendants from deducting their check of dues from their salaries, having proven abortive, as the defendants have continued the deduction of the check of dues from their salaries to date. That the pay slip of some of the claimants was pleaded, and claimants rely upon same at the hearing of this case. That the constant deduction of check of dues from their accounts is not proper after expressing their desire to leave the first defendant union. But the first defendant has received the total sum of 390,832 naira and 22 kobo as check of dues from the claimant's salaries. CW tendered a letter of withdrawal of membership dated 25th August 2020, and same admitted and marked as exhibit CW001. Claimant, the CW1 was cross-examined by both first and the second defendants. Kemonapri Idigbe, who testified as CW to identify his deposition on oath made on the 6th day of March 2021 and adopted same as evidence in proving the claim of the claimant. CW intended a letter of withdrawal of membership dated 18 September 2020, and same is admitted and marked as exhibit CW002, and he was also cross-examined. Comrade Barnabas C. Simon, who testified as DW Comrade Barnabas C. Simon, who testified as DW1, identified his deposition on oath made on 16 June 2021 and adopted same as his evidence in support of the case of the first defendant. DW1 stated that the claimants are still financial members of the first defendant, having not withdrawn their membership properly. Can you hear me? Can you hear me?
Yes, my lord. I can hear you, my lord.
Okay. Okay. DWN stated that the claimants are still financial members of the first defendant, having not withdrawn their membership properly. That it is not the duty of the first defendant to deduct check-off dues from the salaries of the claimants. The duty is that of the employers of the claimants. The letters written by the claimants should have been directed to their employers. That the various letters pleaded in the paragraph 6 of Settlement of Facts are flawed in a number of respects. That the union is not charged with the responsibility of deducting the claimant's check-off dues or ensuring the check-off dues are no longer deducted. Neither has the union ever assumed the duty of deducting the claimant's check-off dues or anyone else. The letter was addressed to the first defendant with the instruction that the check-off dues of the claimant should no longer be remitted to the first defendant, when the letter ought to have been addressed to their employers. The claimant solicitor wrote on behalf of all the claimants jointly. One such letter should have been written individually, since voluntarily opting out of union is supposed to be individually undertaken. DWM further stated that the suit is incompetent. The claimants have been failed to fulfill the condition precedent of instituting this action, which is by writing their employers of their desire not to have their check-off dues remitted to the first defendant, which is the only union that can unionize them. That there is nothing before the court to show that second, fourth, sixth, and ninth claimants individually wrote to withdraw their membership of the union to their employers or anyone at all. The claims of the 14th claimant is started by having been filed outside the 3 months period required to file an action against a public officer. He wrote his letter of withdrawal on the 29th day of November 2019 and filed this suit a year later on the 10th day of November 2020, which is clearly outside the 3 months period allowed by the law. That the claimants force the condition on themselves because they choose to use the wrong approach. DW1 was cross-examined by the claimants, was also cross-examined by the second defendant. DW2 is one Mr. Odaibo Harris Elaibo, who testified as DW2, identified his deposition on oath made on 12th day of March 2021, and adopted same as his evidence in support of the defense of the second defendant. DW2 said an address to the exam board by State, which was admitted and the reply on points of law filed on the 7th day of June 2022. Hmm? Secondly, whether this suit is incompetent, having been commenced jointly by the claimants instead of individual as envisaged by Section 14(2) of the Trade Unions Amendment Act 2005 and Section 5 sub 3 of the Labour Act. And C, whether this suit is incompetent, the claimants have failed to fulfill the condition precedent in instituting this action, which is by writing their employers of their desire not to have their check of dues remitted to the first defendant, which is the only union that can unite the claimants who accept check of dues. Claimants can enjoy the benefits accruing from the negotiation by the first defendant after their exit from the union. The second defendant submitted a sole issue for determination Having highlighted the issues nominated by Learned Counsel for each party, my punctilious reflection on the issues nominated by the first defendant reveals that issue 1 and 2, nominated by Ahmed Adetola Kazim, were designed to be a preliminary objection to strangulate the assumed lifeline of this suit, even though they are not issues relating to preliminary objection. The issues touch on substantive claim of the claimants. Nevertheless, this court will still consider them. Issue 3 is seemingly speculative and academic, and even if it is not, there is no relief of facts connected with issue 3 raised by the first defendant counsel. Hence, there is no nicety in dissipating energy on the issue that I will adopt issue 5 formulated by the first defendant since it touches on the counterclaims reliefs. In order to put this case in a proper perspective, the court finds it most convenient to harmonize the issues submitted by parties and formulate issues that will take care of the concern of the parties. Firstly, I formulated 2 issues for determination. 1, whether this suit is competent to activate the jurisdiction of this court and whether the claimants have proved their case on preponderance of evidence to entitle them to the relief sought. And secondly, whether the claimants can enjoy the benefits accruing from the negotiation by the first defendant after their exit from the union. On the first part of this issue, issue 1, the defendant argued that the second to 16 claimants failed to present themselves before the court as witness. Neither was the letter of voluntary presented as evidence for the court. Counsels further argued Section 12(4) Trade Union Act 2005 against Sheun submitted that claimants individually wrote any letter at all to withdraw or purportedly withdraw from the first defendant's union. That physically available in court to tender it or react to this argument. However, it can be said that the contestation of the first defendant is that the defendant was tendered. The first defendant, in its effort, cited Section 12(4) of the Trade Union Act and Section 5 sub 3 of the Labour Act, and the case of Newsday against Sheun. Though the argument of Learned Counsel for the first defendant is impressive and sweetening, but it is bereft of legal potency to sway the mind of this court. The provision of Section 12 sub 4 of the Trade Union Act, Section 5 sub 3 of the Union Act, Trade Union Labour Act, and the case of Nosday against Shehu, cited by counsel, are unconnected to the issue at hand. Proviso to Section 5 sub 3 of the Labour Act acknowledges the provision of Section 12 sub 4 of the Trade Union Act, which deals with voluntariness of membership of a trade union. These sections have nothing to do with how the claimants ought to conduct their case. In fact, there is no rule of law or practice which says that all the parties on record in the case must testify in the case. In CRSN Corporation against Oni, the Supreme Court held, and I quote, the first point that must be made before here is there is no rule of law or practice which requires a plaintiff in a civil suit to be physically present in court or to testify if he can otherwise prove his case. Indeed, it ought to be mentioned that there is also no such rule which compels a defendant in a civil suit to appear before the court and to testify before he may successfully defend and prove his case without presenting himself in an appropriate case may be entered in a suit so long as they are duly presented. And the third plaintiff testify on behalf of all the respondents. It is clear that the said respondents from the date of the pleadings, the evidence before the trial court, and the law applicable thereto conclusively establish a case of defamation against the appellant. The respondents are able to establish their claims without each testifying on his behalf before the court, and there is clearly nothing fatal to their case in this regard. Unquote. I cited British and French Bank Limited against Social Saad, Kende against Ogumbumi and others. On the issue of whether there is any of the resignation letters of 2nd to 16 claimants before this court to commence this action, this will be addressed in the latter part of this judgment. The first defendant further argued that this suit ought to have been brought separately and may only subsequently be consolidated for the case. It is my considered view that the procedure adopted by the claimants provided for under Order 13 of the rules of this court, which provide that all persons may be joined in an action as claimant in whom any right to relief is alleged or exists, whether jointly or severally, and judgment may be given for such claimants as may be found to be entitled to relief, and for such relief as a claimant may be entitled to without any amendment. Flowing from the foregoing, the court is a firm stance that the suit is competent to activate the jurisdiction of this court, and the claimants before the instant suit, since their claims are the same as a result of the action or action of the defendants, as cited in 2022, 13 NWLR, Part 1847 at 361. On the second arm of issue 1, the claimants pleaded and led evidence to show that due to some of the activities of the union that they are not satisfactory, that were not satisfactory to claimants, they decided to tender their resignation from the union. They are often tendering their resignation from the first defender union, bias as state branch. The claimant letters of resignation to the first defender, and also copied the second defender expressing their desire to leave the first defender union, and also inform the first and second defender to stop any form of deduction of check of dues from their salaries as they are no longer members. CW and CW2 tendered exhibits CW001 and CW002. The first defendant, paragraph 8 of its amended statement of defense, admitted to have received resignation letters from the claimants. The second defendant, by its statement of defense, admitted that the claimants have contracted out of the first defendant. Further proof that the second defendant is not oblivion of the claimant's unwillingness to continue to remain as members of the first defendant. CW2 stated under cross-examination that the second defendant even arranged for a meeting when the second defendant received their resignation letters. The claimants argued and cited Section 5(3)(b) of the Labour Act to the effect that all the claimant needs to do is to write for the deduction of the check-up dues to be stopped and submitted that the claimants have satisfied the provision of Section 5 sub 3B of the Labour Act by writing what to have stopped the second dependent salaries of the claimant and paying same raised on the letter of withdrawal written by the claimants to the first dependent seeking to withdraw from the union. That only documents tendered by the claimants are exhibit CW001 and CW002. That reaction to a letter is for the main addressee alone. That the first defendant has no positive action to make in response. That the first defendant further argued that there was an acknowledgement by the first defendant on exhibit CW001 and CW002, but there was no such acknowledgement by the second defendant, and exhibit CW001 and 2 will provide satisfactory answer as to why cited the case of Bakari against Ogundupe, reported in 2020 LPLR 49571, that it is the employer that ought to be written to when any employees seek to withdraw from a union, cited Section 12.4 of the Trade Union Act and Section 5 sub 3 of the Labour Act. The second defendant, after quoting paragraph 7 of Statement of Facts, paragraph 6 of the first defendant's statement on oath, and paragraph 7 of the second defendant's statement on oath, argued that the logical deduction that could be drawn from the above piece of evidence from the claimants and the first defendant is to the effect that the letter of withdrawal of membership and stoppage of deduction of check-up dues of the the second defendant for reference or due consideration to evidence on record and to Corp International Limited against Diamond Bank PLC. Furthermore, the defense raised by the second defendant in paragraph 7 of statement of defense to the effect that the rules of engagement and the relevant administrative procedure that established the second defendant, it does not have direct dealings with any member of any professional association, body, or trade union itself. Thus, acting under the rule of engagement, the first defendant wrote on the 1st of November 2018, instructing the second defendant to deduct check-up dues of its members in Basa State Government, and that directive is yet to be withdrawn. I find this defense rather moonshine and dereliction of responsibility by the second defendant. The second defendant does not need a directive from the first defendant before deducting a check-up dues from the eligible members of the trade union. Consequently, the second defendant does not also need an approval from the first defendant before stopping a deduction of check-up dues from the claimants, when the claimants have already notified the defendants the resignation from the first defendant. In the case of Udo against OHMB, the Court of Appeal held, and I quote, from the above provision, it is clear that an I also cited the case of Governing Council of NTI Kaduna and others against non-academic sub-union of educational and associated institutions. Suffice to say that the claimants in this case wrote their letters of resignation severally addressed to the first defendant and copied to the second defendant. To my mind, the purpose of copying the second defendant is not to keep the letters for record purpose, but to take a cognizance of the fact that the claimants are no longer members of the first defendant and stoppage of deduction of their check-off dues from the claimants, from the salaries of the claimants. Besides, the first defendant made a heavy weather argument as paragraph 4.04 of its final written address that there is nothing before this court to show that second 16 claimants individually wrote any letter to withdraw or purportedly withdraw from the first defendant. However, the first defendant under paragraph 8 of its statement of defense admitted that it received resignation letters from the claimants. In Yashe against Kumar, the court held, and I quote, "It is an elementary principle of procedure that facts pleaded by one party and admitted by the other will generally need no further proof. But there are circumstances in which the documents are pleaded, and although admitted by the other party, will need to be tendered in evidence in order for the court and to give them proper interpretation. 16 claimants were when DW1 was further asked why did the first defendant address exhibit DW001 to the second defendant, DW answered that the reason that exhibit DW001 was written to the second defendant is that the second defendant is supposed to be preparing the salaries, and the second defendant remit whatever that is due to any group of people or union. DW further stated that he does not know whether the local government council or the second defendant is the employer of the claim. And the response of DW2 to the questions during cross-examination has cast doubt on the credibility of DW2. In fact, let me reproduce the relevant paragraphs of exhibit DW001. This request is stated based on the ongoing transition of primary healthcare workers from local government areas to your board, primary healthcare development board. Note, prior to the transfer of primary healthcare workers to the board, the union check-up dues were paid to us through our branch chairman in the bar. This premise on the foregoing evaluation of evidence before this court and application of the law, I entertain no doubt that the claimants have proved some part of their claim. Hence, some of their claim must succeed. I hereby resolve issue 1 in favor of the claimants. Reliefs A, B, and E sought by are granted, and I so hold. Looking at relief C and D of the claimant's claim, one can see that it falls under special damages. The FCDZ, that is the evidence of the plaintiff's simplicity laid in proof of special damages, must be comprehensive and credible, and it must required is the plaintiff. That would suggest that he indeed is entitled to an award under that head. Cited Emirates Airlines against Mogadi number 2, and Orient Bank PLC against Blantyre International, and SPDC Nigeria Limited against Table the 7th. Strict rule of special damages does not mean an unusual. It simply implies that the party who has the advantage of being able to base his claim upon a premise calculation must either other party access to the facts, which make claimants fail to show to this court how they came C and D, and there is not good evidence to such fact. Refused. On issue 2, which touches on counter defense, the first defendant counterclaimer adopted paragraph 1 to 515 of the statement of defense to establish his counterclaim. A careful perusal of the aforementioned paragraphs is not connected to the counterclaim's relief. In the same vein, adopting the facts pleaded in defense to statement of facts is not proper procedure to establish counterclaim. In the case of Olukemi against Airtel Workers Limited, reported in 2021, 2 NWLR Part 1761, 499 at 537, paragraph D, Court of Appeal held, and I quote, the recognized practice is to separate the facts relied upon to sustain the counterclaim as much as possible from the remaining part of the statement of defense, and to arrange them in numbered paragraphs with the word counterclaim prefixed to it as hearing, so as to distinguish it from what is pleaded simply as a matter of defense to the statement to the plaintiff's claim, unquote. Hence, what is left now is paragraph 7 and 18, and evidence adduced in support of the counterclaim. The first defendant argued in support of release A to C of the counterclaim that DWN stated under cross-examination the efforts made by the leadership of the first defendant to ensure that all the arrears accruing to members of the union, including the claimants, are paid. They also negotiated an increase in the salaries and emoluments of members of the union. CW and CW2 confirmed payment of arrears and increase in salary and emoluments under cross-examination. That if the claimants withdraw from the union, they should not be allowed to benefit from the result of the negotiation made by the first defendant on behalf of members from the date of such withdrawal. The negotiations, travels, meetings, and other expenses involved of members of the union, and it will be of the first defendant. It is an argument, but a trade union. Though role of it, the fact is that at the claimants entered as at when, even without the presence of the first, the claimants having contracted out of the first defendant lose certain privileges or rights which members of the first defendant are entitled to. However, not being members of the first defendant cannot be a basis to deny the claimants their entitlements that are due to them from their employer. The claimants do not work for the first defendant, but the second defendant or the government of Bayelsa State. Hence, the first defendant cannot use it, unionism, to deprive those who are not its members their legitimate entitlements. Flowing from the foregoing, I bear hold that the first defendant counterclaim is entitled to only relief A of the counterclaim and is hereby granted accordingly, and I refuse prayer B, C, and D as contained in the counterclaim, and I so hold. For the avoidance of doubt and clarity, and for all the reasons stated in this judgment, I hold as follows. I declare that the claimants are not members of the first defendant union, having willingly withdrawn their membership from the first defendant union. I grant an order of perpetual injunction restraining the second defendant from further deducting check of dues from the claimant's salaries and paying them to the first defendant. Relief C and D are dismissed for lack of proof. I declare that the claimants are no longer entitled to benefit from all the privileges attached to the membership of the first defendant as a result of their withdrawal from the first defendant as prayed in Relief A of the counterclaim. Reliefs B, C, and D as contained in the counterclaim are hereby dismissed. I award no cost in the spirit of peaceful industrial relations and advancement of trade unionism, and judgment is hereby entered accordingly.
My Lord, we are most grateful for the judgment. Even though the network was not very good, we lost some of the what's it called? The points in the judgment. Yes. So we would hope that we can get the judgment very soon so that we can study and know what next action we may take. We are most grateful to your Lordship, sir.
Yes, the judgment